And before we go to specific comments or questions regarding this topic, there was supposed to be time on the agenda at the beginning for general public comments. So if there is anyone in the room or online who wishes to make a general public comment, then please raise your hand or make yourself known. Yes. Yes, sir.
I don't have a microphone.
Oh,
yes, you will.
In this room, I'll guarantee that.
You'll need one for Zoom.
Yeah.
Yeah, I need one for Zoom. Yeah, we got the spare seat right over here.
Okay. Yeah, you do.
This typewriter is something very simple. My father had it, but and that's where I learned. Yeah, I know.
Also, I just want to remind everyone that everyone will be limited to 3 minutes and I'll be keeping the time. So I'll gently let you know. Go ahead.
My name is Pete Arkeson. I would like to congratulate those that are going to be the new members of the Board of Governors as they start after this meeting or at this time. I would like to see that they do this year moving forward. Number one, start looking at competence. I have written 2 seminar proposals, which both in one way or another talk about competence. We are gone to a silo system and we don't talk about anything other than the legal issue within that we wanted in that silo. We don't look at what other areas are impacted by what is here. I tried to get this pushed through to for the Bar Association to do a seminar on this, and I got shot down. I got told, go talk to a section. Sections don't jump from one issue or one area to another area. They don't have cross-pollination. And the Bar Association has needed it because as a trustee in bankruptcy for 45 or 50 years, I saw a tremendous amount of malpractice because people did not know other areas of law other than what was in their little silo. Number 3, when the Bar Association asked for people to be volunteering for things, people put their hands up and they are not necessarily even contacted about what they have to offer or what they can do or otherwise. For example, you've asked for years for people to sign up to speak at seminars. And I've done it for years, and I've never had a single inquiry at all about what I could do or say or otherwise. When governors say that something will happen, the members should have the opportunity of expecting that there will be a result. For example, about 8 months ago, 10 months ago, I talked to the treasurer and said about an idea what could be generating a significant amount of money through the bar news. The treasurer said, I'll have somebody contact you. I have not heard word from either the treasurer or whomever he or she designated to do something. It is time that the value of the members be actually realized. It has not been. And it is even worse when you look at who gets the appointments along the wayside.
That's time.
And you will find that a very disproportionate people that get appointments, get anything, have a 206, a 253 area codes and 425. Those are the ones around. The board has not the organization is not sought out to get the people that put their hand up and give them something to do. Now, I'm out of time. Typical lawyer. I always have more words to say than are authorized.
Thank you,
I
sir.
should ask, is there any questions?
Thank you, sir.
All right, next is Tyla AA.
Good afternoon, members of the Board of Governors. My name is Tyla II, and I'm requesting that you adopt the proposed amendments to the WSBA standards for indigent family defense. For over a decade, I've worked in family defense, leading a team of passionate attorneys committed to ensuring that every family, regardless of their circumstances, receives a fair and just process. I've seen firsthand the profound impact that public defense has on our entire community. Being a public defender is a privilege for me. It's challenging and often thankless work, but the reward lies in the people we represent, the clients who have taught me more about strength, perseverance, and hope than I ever could have imagined. But we are at a breaking point. I'm here today because I believe that if we're serious about achieving justice, eradicating systemic racism, and fostering equity, then we must prioritize and strengthen public defense. Public defenders play a critical role in balancing the scales of justice, and yet we're often overlooked in favor of our colleagues in prosecution or private practice. The attorneys I know who dedicate their lives to this work do so not for the money or recognition, but because they believe in the people they represent and the power of justice. Unfortunately, the systems they work within is pushing them to their limits. The mental and emotional strain this work has led to high turnover. Since COVID, our team has experienced a complete turnover of associates. Every attorney who has left my office has also left family defense entirely. They have sought higher paying positions and more manageable workloads, and this speaks to a systemic issue. It takes at least 2 years of on-the-job experience before an attorney is truly equipped to handle the complexity of a family defense case independently. These cases are not static. The facts evolve, and that requires a unique skill set and constant vigilance. When an experienced attorney leaves, we not only lose their legal expertise, but also the deep trust they've built with their clients. The learning curve for new attorneys is steep, and during that transition, the quality of representation can suffer, leaving vulnerable families without the full benefit of experienced advocacy. This turnover is not just a disservice to our clients, it weakens our entire system. The most oppressed and marginalized in our society deserve the best possible representation, and yet the current conditions for public defenders make it nearly impossible to provide that consistently. Public defenders are the backbone of the legal system, but all too often we're treated as though our work is less valuable. The contracts awarded to public defenders may appear as higher salaries than some state attorneys, but that figure quickly diminishes once you consider the cost of running a practice, office space, support staff, insurance, supplies, and more. What's left is far below what private attorneys and state attorneys make. I've been an attorney for 17 years, almost entirely in public defense, and the only reason that I've been able to do this work for as long as I have is because I'm fortunate enough to be married and my husband covers all of my expenses. This allows me to do this work for very little pay, and this is not a situation that is available to everyone. Last week, I received notice that my student loans will be paid off in 300 months from now. That's 25 years. I'll be 69 years old. As public defenders, we know we're not going.
Go ahead and wrap up.
I ask you to stand with me today in support of public defense. If you value justice, if you believe in equity, then you must value public defense. And if you support work that safeguards the rights and futures of our families and our community, then you must support the adoption of these standards. Thank you.
Chris Desmond.
Thank you. My name is Chris Desmond. I run a 6-attorney law firm in Southwest Washington, and I'm speaking today to support the adoption of the new, the proposed dependency and termination family defense caseload standards. I've been a member of the WSBA for just over 20 years. The last 18 or so, I have spent representing parents and children in dependency and termination proceedings. And we currently do that in Mason, Thurston, Grace Harbor, Lewis, Cowlitz County, Pacific, Wahkiakum, and we spend a lot of effort and time to represent the families across Southwest Washington. These are the poorest families, that our society has. And they are being faced with the most dealing with some of the most complex systems our society has, including a legal system and dealing with DCYF and the government bureaucracy that it is. And they need skilled attorneys to help them navigate those systems and advocate for them. And they need attorneys who have the time and resources to do that. So I urge you to adopt the Family Defense caseload standards so that attorneys have adequate time to advocate sufficiently for their clients in court, that those attorneys have the time to do all the out-of-court work to help their clients interact and navigate DCYF and the government bureaucracies that they deal with. And it's, as Ms. II spoke to just previous to me, we need lower caseload standards so that it prevents burnout of attorneys. Turnover in attorneys is not good at all in this legal field. There is an expertise that is needed to adequately represent parents in these complex legal proceedings, which involve the deprivation of rights from parents of their children, and what's known as often called the civil death penalty, which is termination of parental rights. It requires years of training and experience to be able to adequately represent parents in the best way possible. And so I urge you to adopt the caseload standards that are being proposed that I think you're all considering tomorrow morning. Thank you.
Thank you. Next is Adam Balut.
Thank you, everyone. Good afternoon, Board of Governors. My name is Adam Balut. I've been a public defender in Washington State for 17 years, and alongside Tyler II, we have a public defense firm in Snohomish County. I'm strongly urging support of adoption of the new proposed family defense caseload standards. It's been said that the time to repair the roof is when the sun is shining, and a strong, high-quality, consistent parent representation is a Washington State citizen's greatest defense against government overreach, due process violations, statutory and constitutional violations, against arguably one of the oldest and most sacred rights we have as human beings, the right to parent. A strong, high-quality, consistent parent attorney can expose these faults in our system, and if trained properly, identify and bring these issues to light so they can be addressed by the courts. I want to quickly point out two key facts about the Oregon public defense crisis, which ignored calls for help until their system collapsed. The price tag now to fix their public defense crisis is north of $100 million. Their attrition rate, second fact, their attrition rate for new attorneys being recruited into the crisis is 75%, meaning last year they hired 113 new lawyers, and a year later, only 25% of those remain. And while I understand that cost will be the primary objective to these standards, I urge you to think of this not through the lens of cost, but as an investment in families, an investment in justice, an investment in our value of equal justice for all, an investment that will pay dividends, not just for our current defenders, but for future compassionate defenders and the families that they serve. Thank you.
Thank you. Next is Anya Parrott.
Thank you so much. My name is Anya Pare. I am a attorney in King County representing children and families as a public defender. Prior to law school, I worked for 5 years as a social service professional in what we called the child welfare system. And I initially dating myself a little bit, but became a foster care caseworker in 2011, thinking that I could help work to fix the system from the inside. I quickly realized that the child welfare system is at best a barbed wire safety net, and at worst, a deeply, deeply unfair and unjust system that separates children and families unnecessarily. I agree with my colleagues from the ABC Law Group and Chris Desmond, and I'd like to talk about one specific issue, which is the way that public defender caseloads in the dependency and termination system contribute to court congestion and delays in adjudication of these cases. That may sound like a boring or pedantic issue, but for the children who are unnecessarily separated from their families, it is anything but. I was first inspired to go to law school when, in 2011, as a foster care caseworker, I worked with a family who was separated. A young mother had her children removed. And at adjudication, dependency, or the state I worked in's equivalent, was not found. So at trial, she prevailed and her children were returned home. However, her children had been out of her care, bounced around from foster home to foster home for more than a year. And while she might have been okay, her toddlers definitely were not. My belief in my ability to work within the system and help families in light of that type of harm was lessened. So I went to law school and became a public defender representing families. But today, with the caseloads that we have in Washington, I have to reckon with the fact that I am complicit in that same type of delay, not because I don't want to work hard, but because I cannot physically run multiple trials at the same time, which means that with meritorious cases, when a case comes in that I know we can win at trial, I know we can reunify a family, I still often have to tell parents, or even more painfully, child clients, that they may be separated for more than a year. It's deeply disturbing and contributes to the moral injury suffered by public defenders who burn out and leave. And the Washington State Bar Association has a way to fix this issue. Please, please do. Thank you.
Thank you. Next, we have Jennifer Justice.
Good afternoon, Board of Governors. My name is Jennifer Justice, and I'm a parent ally. Public pretenders, that's what they were called where I grew up. Then I grew up and saw or was personally represented by a few of these public defenders. It just reinforced the belief that that if you were going to be assigned a public defender, that you were never going to be remembered because their caseloads were too large, or they were not able to properly represent you because of caseload, turnover, or lack of knowledge. It was just a fact that unless you had money and could afford a real attorney, you were in trouble. In 2015, I was assigned multiple public defenders during my dependency. I will own my part in being a difficult client, but I was in a personal battle with addiction and the fight of my life for my children. No one heard me, no one saw me, and I never felt properly represented. And in the end, I lost the fight for my children. Fast forward to 2020, knowing CPS was going to come again, I was given the chance to be represented by who I later would find out were public defenders. And my life and my outlook changed. I was respected, seen, heard, and had someone truly fighting for me to have a second chance at being a mother. Thank you to ABC for representing me. They saved my life and got me a second chance. 2 years later, I graduated from community college with my AAA in legal administrative assisting, and that this law firm connected me with another law firm to do my internship. During this time is when I learned that not only this office, but the office that changed my life were public defenders. I was in total disbelief. No way that were these amazing people public defenders. These two law firms worked what seemed like around the clock tirelessly for their clients. They didn't just know their cases, they knew their clients, truly knew their clients. Today, I'm a productive member of society because of this amazing group of public defenders, some of which I have the privilege of working with. I watch them work long hours with huge caseloads. I watch them work with difficult clients, social workers, community members, and more. I watch the secondhand trauma they go through working in the family justice system. I watch them cry tears of joy and pain when representing family and kid clients. Their careers are far from the glamour or single episode victories we see on TV. They are the heroes that stand between the people and system that often seems determined to see them fail. I'm asking you to adopt the new standards for public defense. They deserve to be seen, heard, and respected the way that they see, hear, and respect their clients. They are the backbone of the justice system, and without them properly being supported, I fear what the future looks like for my children and for our communities. Thank you.
Thank you. McKay Campbell.
Hi, my name is McKay Campbell. I've been a family defense attorney for 4 years with the King County Department of Public Defense, and I'm asking the WSBA to pass the amendments for family defense on caseload standards. I strongly agree with the other perspectives that have been shared, but I want to share 2 additional perspectives of the benefits from my perspective. First is how impactful caseload standards are on attorney recruitment in public defense. I am a graduate of NYU Law, and as an alumna, I frequently am speaking to 3Ls who are applying for public defense jobs across the country, and fortunately, they are considering Washington State. Public defense is immensely hard, and 3Ls know that, and they are often trying to find somewhere sustainable to work, and that is a key factor in their decision. It has been a huge deal to be able to say to these candidates that the Bar Association here in Washington, that they see how hard public defense work is, and that they have done already tangible things, first in criminal defense and now hopefully in family defense, to stop Washington from becoming a churn and burn state. And I can say that I know for a fact that we have already stolen a few good public defense candidates from other states because of what WSBA has already done for criminal defense. I'm hoping that the same can be done for family defense as well. A second perspective that I wanted to share is that as family defense attorneys, we also represent children and youth in the foster care system. That is an incredibly expansive scope of representation when you represent a child, because for that child, the dependency case isn't just, one legal issue in their life, it is their life. As a dependent of the state, the court is making decisions about every aspect of that child's world, and their only way to have their voice heard is through their dependency attorney. So I am litigating school choice, where they live, access to healthcare, access to gender-affirming care, and legal name changes. I am at IEP meetings. My scope of practice for those clients is immense, and it is a lot of work, and it is incredibly important work. And I think that is the most true for children I represent who are legally free. That is kids who have had their parents' rights terminated and are what we call legal orphans. In my opinion, these are the most vulnerable children in the entire country. All too often, they are children with disabilities who in state custody have essentially been warehoused in these for-profit institutionalized settings out in Eastern Washington. And for these kids, they have no parent to advocate for them anymore. So what they have is an attorney. They have me to make their voice heard to the judge who can make every decision about their life. And I don't have enough time to offer them effective representation. I just don't. And I can't tell you how hard it is to not have enough time to effectively represent these children, or to effectively represent these children and have that trade off with the time that the rest of my clients should be getting from their lawyer. So I am asking the WSBA to please adopt the amendments to the standards for family defense. Thank you.
Thank you. Next up, Matt Bjork. Okay, now Matt, try again.
Can you hear me okay?
Yes.
Okay, thank you. Thank you so much. My name is Matt Bjork, and I work at King County Department of Public Defense as a public defender in the family defense area. I, too, am asking the WSBA to adopt the amendment to the caseload standards. I came to Seattle actually from Oklahoma. I was a special education teacher there for about 7 years, so I may be addicted to professions with high caseloads. But I did want to talk about really just kind of the honor that I have to represent my clients, and ask you that you lowered the standards so I can effectively represent them better, essentially, right? I feel completely honored to go after Jennifer Justice because she touched on something that we all know as public defenders in family defense. We actually have to know our clients and not just know their names and the facts of the case, but know everything about them and what makes them tick and what they love about their children and what their children's favorite toys are and what their favorite foods are, so that then we can go in and advocate effectively and actually represent them. I've been in King County now for 6 years, which is not a long time. Like, I graduated in 2018. That's not that long ago. I'm one of the most tenured public defenders in family defense now. In fact, just last week, I was able to fill in for my supervisor when she was out because of my tenure there. To me, it should be longer than 6 years where you have the most tenured people. But unfortunately, we're losing a lot of people, great people, to burnout. And every time they leave, they literally come up to me and tell me, Matt, I love this. I love my job. I love everything about it, but I just can't do it anymore. The caseload is too high. So I think this would make really an effective difference, not just in our lives as attorneys, right? I mean, who kind of cares about us? I mean, I guess we're kind of important, but really in our clients' lives and the continuity that they need for their attorney. They can't go through 4 attorneys in 1 year and have the most effective representation that they have. So I'm asking that you all adopt these caseload standards. I think it will make a huge difference to people like Jennifer Justice and other people that inspire me day in and day out. And hopefully we'll keep some of my colleagues around. Thank you.
Thank you. Those are all the hands online.
Oh, there's one more.
I'm sorry for anyone that I get your name wrong. Grineen Griffiths.
Hi, thank you so much. And it's my name is Grania Griffiths. It's a very complicated Irish name. I am a public defender in King County, and I ask that you adopt these caseload standards today. For me, for my colleagues, and most importantly, for our clients. I had another statement prepared today, but I had an experience in court yesterday that I wanted to share with you all, and I have full client consent to share this story. I have a fantastic youth client who's in extended foster care, and they had a really rough dependency case, and eventually were able to reunite with their parent, but needed a little bit of extra support getting into college, transitioning into adolescence, and so they're in extended foster care. And that client told me, you know what I want to do? I want to be a family defense lawyer. I want to do what you do because I have been a child in this system, and now I'm a youth in this system, and I want to fight for people like me. And she sat in court all day and took really, really good notes. And then we went over kind of what my day-to-day looks like, what it means to represent a parent in an emergency 72 removal hearing, where I just got appointed the night before, what it means to start preparing for trial, what the discovery obligations look like. And we sat down and we actually looked through the discovery from her entire case, 1,000 pages. And I asked her, I said, how many clients do you think that I have? And she said 5. I think you have 5 clients. And it really broke my heart because I should have 5 clients, right? I should be able to represent every single one of my youth clients, every single one of my parent clients, as if I can spend the whole day diving into their case, advocating on all of the areas they need advocacy in, all of the intersections of the system's failures that they're dealing with. And I don't have that time. And I lie awake at night thinking of all of the things that I could do in every single one of my cases to reunite families. And that's the stress, that's the moral injury that I don't know how to deal with. And I'm working my best. I'm processing that with my colleagues, but these caseload standards are going to tremendously help attorneys, clients, and hopefully move the needle a little bit in ending this terribly unjust system. Thank you.
Thank you.
Thank you. And for the benefit of the board, we will be addressing the issue of these standards tomorrow. It's on the agenda tomorrow for discussion. And now I would invite comments on the presentation that you just heard from the Practice of Law Board. Nancy Hawkins.
Well, first, I don't know about you, but I'm ready to vote to improve the caseload standards for public defenders, and I'm not even on the board. And I'm guessing that that'll go well tomorrow. As most of you know, I represent the family law section. I'm their liaison to the Board of Governors. And we are very interested in the practice of law board proposal. And I think the first point I want to make is it's not because we feel we're in competition with these entities. In fact, if you look at the other states, they tend to ignore family law because it's hard and people don't make as much money that if they skim off the easy pickings of wills and personal injury cases and that sort of thing. But we are concerned, and we submitted a letter that talked about some concerns about the confidentiality of data as the process is, as entities are being evaluated. We're concerned about having specific definitions of what makes a suitable person, because Utah started out allowing suspended lawyers and disbarred lawyers. We don't want people in those positions, no matter how much they bring about their good character. Being a lawyer brings with it a stamp of approval. I'm personally very proud of having been a lawyer for 42 years. And clients and public, when they hear you're a lawyer, for most of them at least, it means something. It means that you met some character and fitness criteria. You've done a lot of studying, and you must be able to do the job for them. If we're going to approve various entities, that's going to carry a big weight as well. That's going to mean that we think they have good character to the extent that entities have character. And yet, it's not going to be the same process unless we make it so. But we definitely need to be sure, and we're not opposing the proposal, but we are proposing concerns that these entities have to meet that level of character and fitness to begin with, and maintain it throughout their existence here in Washington. And the only way that can happen is through very diligent, very costly evaluations along the way. It will not be evaluations by the Supreme Court. It might be that in name at some point, but it's going to be a separate organization or a separate board or a separate group, and that's going to cost money. I've heard, I know it used to be at least, that there would be a fairly nominal fee to approve these entities.
Nancy, that's time if you want to conclude.
It's my understanding now that it's supposed to be all their costs. I'm concerned that that money will never be collected. We will continue to make comments to the Practice of Law Board, raising our concerns, those and others. But this is something we need to think very, very strongly about.
Thank you. Next is online, Michael Terasaki.
Good afternoon, everyone. My name is Michael Terasaki. I'm the Washington State Pro Bono Council Manager. I coordinate and support the 16 county-based volunteer lawyer programs here in Washington State. My comment today is to share the current situation in legal aid services, and it's essentially that low and middle-income Washingtonians are not generally, but they are already turning to unregulated and unsupervised online legal services for legal advice and documents. And we see this all the time in legal aid. We have clients come in with bad or incorrect documents that they have paid for through some disreputable online service. So I think with this pilot project, we have an opportunity to put some guardrails and some oversight on innovations in legal services, and this can help tens of thousands of people here in Washington, if not more. I hope this project can give some space for innovation for good actors like nonprofit legal aid organizations, well-meaning existing traditional law firms. And Washington really needs this pilot so we can have the space for the good actors to innovate and improve legal services. Like I said, we're already seeing bad actors here, and the bad actors do not care that they are not authorized to practice law. They're already here, and they're already harming clients in Washington, particularly the most vulnerable and the most desperate for legal services. So I believe that by proceeding with this pilot project, we can greatly increase access to justice here in Washington and also maintain the high standards of quality that our communities deserve. Thank you.
Thank you. Next, we have Tom Gordon.
Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We are a national nonprofit organization advocating on behalf of consumers of legal services. The board here is considering what is essentially an experiment, a pilot program, and we're in fact in the middle of a 100-year experiment of the current model of legal services delivery. As Craig Schenk pointed out, up until a century ago, consumers had a much wider range of legal services options available. UPL definitions were less expansive. It allowed more types of professionals to provide legal services. In addition, consumers could choose from a wide range of businesses that provided lawyers, such as group legal plans that were offered through auto clubs or unions or banks or homeowners associations. None of those entities are allowed to do that today because of the change in regulation that happened around the time of the Great Depression. So this 100-year experiment in restricting business models through which the public can get lawyers has been a complete failure for consumers. One key data point in this 100-year experiment is that lawyers in Washington charge an average of $288 an hour. So that means that the average Washingtonian has to work for almost a full day just to pay for 1 hour of a lawyer's time, which we know is not nearly enough time to deal with most legal problems. Additionally, there just aren't enough lawyers out there to meet the approximate 3 million legal needs a year that there are in Washington state. Each licensed lawyer would have to take on over 800 legal matters annually. And so putting cost aside, that's not feasible when each matter is treated as a bespoke matter rather than something that could be handled on a more innovative, expandable type of model. So allowing non-lawyer ownership is a necessary step toward making legal help more affordable. Just like H&R Block and TurboTax have made it easier to navigate the tax code, a mass market law firm could make legal help more affordable and accessible by using innovation and taking advantage of economies of scale. There's often opposition to these types of reforms because of a claim that non-lawyer ownership would mean the end of lawyer independence. But lawyer independence is already protected by other provisions of the rules of professional conduct that directly address those concerns about lawyers' duties to their clients. Also, the argument about non-lawyer ownership protecting consumers both understates and overstates lawyers' propriety. It assumes that supervising lawyers are saints with no possible motivation to, for instance, encourage padding of hours or encourage their subordinate lawyers to settle the contingency fee case prematurely. But at the same time, it assumes that lawyers have so little commitment to their professional obligations that they'd ignore all their obligations to their client if they were pressured by a non-lawyer employer. Finally, it's important to emphasize how small of a step this proposal is. Despite our 100-year experiment showing that we need to roll back these restrictions on how legal services can be provided, this proposal is a baby step in that it is merely a pilot program, not the wholesale regulation that has taken place in Arizona or in England and Wales or in Australia.
And conclude.
So we urge the board to approve this proposal and recommend that the state Supreme Court approve the draft order. Thank you.
Thank you. I don't see any other hands up. Oh, we do have another one. Mark Alexander.
Well, I really wasn't expecting to speak, and I'll try and make it brief. I'm not speaking on behalf of Domestic Relations Attorneys of Washington, although I'm on their board. That's because we haven't taken a formal position on the proposal yet. First, I wanted to confirm that all written submissions received by next Friday to the published link will go to the Supreme Court with the proposal, assuming it goes forward. Second, the proposal and the framework law review article that it refers to and relies on, neither was in the meeting's written materials, at least as of yesterday. You take a look at page 28 of the written materials, it says there are no attachments, though it refers to them. Third, even the law review article by Mr. Cherry of Practice of Law Board admits that this proposal really is not expected to improve access to justice for those who can't afford attorneys. His phrase, I believe, was, "We punted on that issue." And there's really nothing substantive in the proposal, which essentially refers to a framework, which is the law review article by Mr. Cherry. Now, that law review article, the 25-page article, essentially repeats the earlier draft blueprint and even relies on the applicants to figure out how to monitor and report on themselves and evaluate access to justice impact. The law review article also cites another article written by someone who was on the board regulating another entity in another state, whose article said most states have declined to pursue these sandbox proposals, including California. That's all I had to note.
Thank you. I can confirm that we will pass along all of the public comment that we received to the court.
And I also want to thank Chair Ashley and Craig Shank for your presentation, and we look forward to hearing more from you at a later date.
Thank you for your time.
Thank you.